I'm only the second speaker, but I'd like to show my outline.
Tamar, can you take one?
So when you hear me speaking, and maybe I'll ask you at one point, my students.
Can anyone hear me? Is it still working? If you can hear me, we're going to try to start up a new event here in just a second. And people who are standing uncomfortably and packing the hallways, there is a balcony with open seats. You might be more comfortable.
Okay, we're getting started again, folks. Please get your seats. Please take your seats so we can get started. We're getting behind schedule. We're going to get people coming inside, so get your seats now.
Oh, there you go. Hi, I didn't meet you.
How are you? Hi, Ray. I'm Gail. Hi. Nice to meet you. And Ray, this is Daniel. Hi.
You each want to speak from the podium, and then we'll take questions from your seats. Does that sound good? All right, is that good with you?
I better take my watch with me. I'll wait till the introduce. Yeah, probably a good one. Okay, so let me think what I'm going to say about that.
Okay, folks, we're getting started. Okay, I know. We're going to start in a minute or two. Tony's ready. Good. All right, folks, if you take your seats, and we have our panelists ready. We'd like to get started. Thank you very much. Go ahead and come on in and get your seats if you like. Okay, first off, my name is Kevin Zeese. I'm the co-director of Popular Resistance. I want to first off thank the World Beyond War staff, volunteers, people who are working on this meeting for doing such a great job getting this started. Please give them all a round of applause for their great work. I really want to thank them for starting the evening off with showing us that while we have to end wars around the world, we also have to end wars at home. Wars at home and wars abroad, that is our goal. Decrease this militarization. So this session is on using the rule of law to legalize peace. We have three great panelists. The format of the session is going to be that each speaker will speak for 15 minutes, and then we'll have questions about 40 minutes if we can stay on schedule. My speakers, I hope that you'll keep to 15 minutes so that we can have time to have a dialogue, because I know it's a great audience, and I know that the dialogue is really the richest part of these kinds of events, so we want to make sure we have that happen. Let me first introduce this panel by saying I'm from the United States. I'm from Baltimore, Maryland. We definitely have a war at home, and unfortunately my country is a leader of wars abroad. And I'll say the United States has been in a constant, never-ending war all of this century. Let me just change that phrasing a little bit to make it relevant to this panel. We have been involved in a never-ending illegal wars for all of this century. Illegal wars. And the reality is it's been true not just for this century. It's been true since World War II. The United States wars, the United States have started, or wars that the United States has started or led have killed 20 million people since World War II. 20 million people, all these wars are illegal. Now we just add to that. Once you have an illegal war, every action taken in an illegal war is a war crime. Yeah, right. And on top of that, even it's a legal war. The actions taken in these wars, bombing civilian infrastructure, bombing hospitals, killing civilians, torturing people, these are all acts of war. Even illegal war. So we have illegal war, war crimes, and none of it's been investigated or prosecuted. It's not been investigated in the United States. Our constitutional law former president, our constitutional lawyer, former president, describes himself as being a constitutional lawyer. He claims to be. We want to look forward, not backward. We refuse to investigate the torture. So now who's head of our CIA? The torturer. That's what happens when you don't prosecute crime.
I think your microphone might not actually be on. Yeah.
No,
It's just quiet.
I'm told it's just a quiet mic, so I'm going to have to pick it up. So let me say that. Oh, that's better. Thank you.
Try this one.
No, I think it's sounding better. Is it better? Everyone sounding better? Okay. So President Obama looked forward, not backward. Torturers were not prosecuted. Laws were not enforced. And as a result, now the head of the CIA is a torturer. Someone implicated in torture. Now, recently, the International Criminal Court talked about investigating and prosecuting potential war crimes in the United States and Afghanistan. The response, John Bolton threatened sanctions against investigators, prosecutors, judges. We want to investigate the crimes ourselves, and we threaten those International Criminal Court who would. That's not acceptable. And I think that the peace movement needs to stand up for the International Criminal Court and stand against John Bolton, who was in the Bush administration when the war crimes that they want to investigate were allegedly being committed. So it's time for us as a movement to say, no, we will not threaten international law and help to enforce international law. Let me say this about the times that we're in, and then we're going to get to the panelists right away. First, we are ending a time when the United States was the unitary power, a time when our hegemony ruled the world. That time is ending. It's not just me saying it. A year ago, the Pentagon published a report about the post-primacy era, when the U.S. was not the leader militarily, when the U.S. was not the leader with corporate power, when the U.S. was not the leader with the size of our GDP. If you measure purchasing parity power, China and the EU are bigger than the United States now, and they have been for several years. The U.S. is fading. This next empire, Alfred McCoy, academic who has studied empires, not just the U.S. empire, but other empires, says the U.S. is a fading empire. So as we're in this phase where finally the ICC is talking about investigating U.S. war crimes, that is the time for us to say it's time for the U.S. to be held accountable. Now, as I say, the DOD did a report on the post-primacy era and what do we do about it. The DOD, the Pentagon's response, we need more weapons, we need more militarism, we need more war. The exact opposite we should do. So in this era where the U.S. has been committing war crimes and conducting illegal wars, killing 20 million people since the World War, in this era when that empire is fading, it's up to this peace movement to figure out what role do we play to bring an end to this brutal empire, to bring some kind of peace to the world. This is an opportunity. And I think when you hear from our speakers tonight, I think you'll understand why law is so central to this. You'll understand that the issue is not for us to end war. Already the wars being fought are illegal. The issue is we just need to enforce the law. That's a lot less scary a goal. Enforce the law, hold the war criminals accountable, and we're going to see a world without war. That's how we'll get there, and that's our job. Let me start with our first speaker, Gail Davidson. In 2004, when Gail Davidson filed criminal charges for torture against George W. Bush, the Attorney General directed the provincial court to dismiss the information, and she fought the case unsuccessfully up to the British Columbia Court of Appeal. In 2012, in response to a report by Gail and others, the UN Committee Against Torture finally directed Canada to arrest and prosecute Bush and others involved in torture. As a result, Bush has not been to Canada. Gail is a legal activist using the law to promote better knowledge about international human rights laws and compel compliance. She is the founder and current executive director of Lawyers' Rights Watch Canada, and was the co-founder with Michael Mandel of Lawyers Against the War. She's going to outline international laws that prohibit and criminalize war, the means of enforcement, and the role of civil society. Please welcome Gail Davidson.
Okay, thank you. Thank you very much, Kevin. Can everybody hear me? Okay, so anybody want to be my timekeeper and tell me when I'm at 5 minutes from 15 minutes and 1 minute? Anybody? The man up there, thank you very much. I'll rely on you then. And it'll be your fault if I go over, I guess. So thank you very much to the organizers of this wonderful conference. I'm honored to be speaking to so many extraordinary peace and anti-war activists. And what I want to do is I want to very, very quickly go over 3 areas of really dramatic law reform that have taken place internationally since World War II, and to suggest to you that that's the way, as jumping off on what Kevin has been saying, that one of the tools that you can try and use to stop war and to promote, to ensure peace. So those 3 areas of changes in the law that really didn't stand the law, in my view, on its head. It stood the law on its feet. So 3 big changes that took place are this. Universal acceptance by the United Nations, the African Union, the European Union, the Organization of American States, in the rule of law principle as the principle that governing legitimate governments and legitimate legal systems. That's number 1. Number 2, starting within the United Nations and also in the other regional organizations that I just mentioned, since the Second World War, there's been the development of a huge amount of human rights laws. So that's all kinds of treaties like the Convention Against Torture, the International Convention on Civil and Political Rights. And these treaties have created individual rights on the one hand, and on the other hand, they have restricted the power of states by imposing on states the duties to ensure those rights and to ensure remedies for violations of those rights. And the rights that are protected, the so-called fundamental rights and freedoms, include things like the right to life, for instance, the right to freedom from arbitrary detention, freedom from torture, rights of association, assembly, rights of expression, and so on. So that's a very important thing. And the third thing is the development through the United Nations and then through the most recently through the Rome Statute of a Criminal Court of first the prohibition against the use of force against what's called the crime of aggression, in other words, war, and the criminalization first through the Geneva Convention, not first, I'm just talking about post-Second World War, the Geneva Conventions and then the Rome Statute, the criminalization of acts of war, war crimes, crimes against humanity, and of course of genocide. Now, alongside those three, so now I've really got four things going, is also there's developed means of monitoring state compliance with their duties to ensure rights and prevent and remedy violations. There's been there's internationally developed means of monitoring and enforcement. So with respect to the human rights treaties, there's monitoring bodies. I'm just going to deal with the UN ones, like the UN Committee Against Torture and like the Human Rights Committee. Those are bodies that monitor state compliance. So, and lots of states belong to these treaties and have agreed to these rights. So for instance, the Convention Against Torture has 174 state parties. The International Covenant on Civil and Political Rights has 172 state parties. And then as far as the International Criminal Court is concerned, the International Criminal Court itself came into force on July the 1st, 2002. Canada left Afghanistan June 28th. No, yeah, right. You can see what. They thought that the court was going to be a little more effective, a little faster than it was. But anyway, so then the International Criminal Court also has the jurisdiction to investigate and prosecute when states can't or won't do it, war crimes, crimes against humanity, and genocide. The crime against, the prohibition on the use of force, the Charter of the United Nations contains a prohibition on the use of force, and under the UN Charter, states are only allowed to use armed force one against the other or to invade the territory of the other in two broad situations. One is where there's a resolution of the UN Security Council directing, authorizing the use of force, and number two is in individual or collective self-defense. But if I can just say that the use of force in self-defense is very restricted. So first of all, there has to be an armed attack, and then the use of armed force has to be necessary. In other words, it has to be the only way. It's kind of like self-defense under the criminal code, but not quite. Has to be necessary, and the force has to be proportional, and under the UN Charter, it's all supposed to be temporary, i.e. until the UN Security Council steps in. States, of course, are currently using anticipatory self-defense as an excuse to invade other countries. Most legal scholars, the UN Charter, unfortunately, is silent about that. Most legal scholars would say that that's not legal, anticipatory self-defense, for obvious reasons. You can fabricate the issue so easily. So now I'm just going to back up a little bit and go back to the rule of law, because I think that that's an important thing for everybody to understand. So simply put, the rule of law refers to a state of affairs in which there are legal safeguards for the protection of individual rights and legal barriers to government arbitrariness, and a system of independent, equally accessible courts to prevent and remedy rights violations and the arbitrary use of power to make or enforce illegitimate laws or to override rights. The 1948 Human Rights Declaration names the rule of law as essential to protect rights and to avoid the need to for individuals to have recourse to rebellion to oppose tyranny and oppression. And I just want to read to you how the United Nations defines the rule of law. It says it's a principle of governance in which all persons, institutions, and entities are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and laws which are consistent with international human rights norms and standards. So it's not just any old law. The law itself has to comply with international norms and standards. Now, the law of aggression was only, the International Criminal Court only took jurisdiction over the law of aggression on July 17th of 2018. In other words, last July, because when the states adopted the Rome Statute in 1998, July 17th of 1998, they couldn't agree on the definition, so it took all the, or on the, how jurisdiction would be exercised. So unhappily, the jurisdiction over the crime of aggression that the International Criminal Court has assumed is very, very narrow. First of all, only 35 states have ratified those amendments, and so the jurisdiction, first of all, only applies to aggression between those states. However, I don't think that should deter you from making complaints to the International Criminal Court. Now, if I can just race on into using those laws and using those enforcement mechanisms. So just to deal very briefly with making complaints to monitoring bodies of the United Nations. This could apply also to monitoring bodies of the regional organizations, but just deal with it. So monitoring bodies, so for instance, the UN Committee Against Torture. Individuals and groups, you don't even have to be a group to make a report. Anybody can file a report. All you have to do is make the deadline and comply with the requirements of report filing, which isn't difficult. And if a report is filed that is well researched, clearly written, and addresses the factual and jurisdictional issues, then it's very, very likely that the recommendations that you ask for in your report will be repeated by the Committee Against Torture. So for example, that's how in 2012, so many years after I tried to have George Bush prosecuted in Canada, and he and his buddies, the Bush administration, they'd been fishing and hunting and of course shooting animals, fortunately not people in Canada, and also having speaking engagements, earning money. And the Canadian government had said to the Committee Against Torture, they said, oh no, we comply with the Convention Against Torture, but as far as arresting and prosecuting people, we just do that to residents. And because of the report that myself and other people filed, the Committee Against Torture said, well, actually, that's not what the convention requires. There's a sort of legal definition of suspect, what a suspect is. And George and all the people in the Bush administration, they were way above that bar. You know, if that bar was there, like they were on the ceiling. So the committee said, no, as soon as a suspect like that enters Canada, it's not just that you have to arrest them, you also have to detain them until either Canada prosecutes them or they're extradited to another place. So that was a sort of thing that anybody could have done, written that report. You don't have to be a lawyer to understand all the thing about these kind of things, so that they take a horrible amount of work. So the same thing with International Criminal Court complaints. So how am I doing for time? Okay, I'll just be really quick. I just want to tell you the happy news about the International Criminal Court. Current investigations by the International Criminal Court confirm the importance of civil society efforts to enforce, because all of the things before the International Criminal Court are fueled by civil society reports. And right now, the International Criminal Court is doing investigations in, amongst other places, I'll leave out the ones you're not interested in, Palestine, Iraq, Myanmar, and Afghanistan. In Afghanistan, the Office of the Prosecutor asked for approval to open an actual big investigation into war crimes and crimes against humanity in Afghanistan by, amongst other things, the U.S. Armed Forces and the CIA. And the request to investigate the CIA war crimes is in black sites that are in Afghanistan and other places. Now, various Canadians have asked the prosecutor to include Canada in its investigation. Now, as Kevin said, John Bolton is telling them that, here's a quote, "If the court comes after us, Israel or other U.S. allies, we will not sit quietly." So just in closing, I wanted to say that we have all been, I know I'm not speaking into the mic right now. We have all been anti-war activists. We've been supplicants, we've been educators, we've been lobbyists, we've waved banners, we've gone to rallies, we've made speeches, we've produced reports and written communications, and all of that work is essential and must continue. But you know what? It is, we all know what I'm going to say, it is not enough. We now have to become the decision makers. We have to become the decision makers, the lawmakers, the litigators. We have to do the work to become the people who force enforcement of the law, because all of those human rights, thank you. All of those human rights treaties that are, and the Rome, including the Rome Statute, there's nobody to enforce them except you and I. States are not, obviously not going to enforce them. Look at how Canada has enforced these laws. Did they ever prosecute anybody for torture? Yes, they did. Who did they prosecute? They prosecuted Mugesera from Rwanda. Why? Because that was somebody from a weak state, and the prosecution was supported by the heavy-duty states. On the other hand, when Lawyers Against the War came along to prosecute George Bush, like, if you should have seen the dossiers of evidence we had, that was even early in the Iraq War. No, all the attorney generals just joined together in a big sing-song, and they crushed us all because there's no way. And then time after time after time, we wrote briefs saying, don't let Dick Cheney in, don't let Colin Powell in, don't let Condoleezza. They're all suspects. They all fit the definition of suspects, and they turned a deaf ear. So it's up to civil society, and you can't rely on the government's lawyers. Once I was giving a talk out at a university, and one of the other people giving a talk was a chief lawyer from the Canada War Crimes program. They're the Department of Justice and the RCMP and CSIS. They're all got tons of money to investigate war crimes. And I went up to say hello to him because I had exchanged correspondence with him. And he said, "Oh, I know who you are." And I said, "Oh, okay, yes." And he said, "I'd like to tell you this." He said, "I've received everything from you and read it, and you're right. I agree with you, but I have a job to keep." So there you are. It's our job to keep now. Thank you.
How are your phone? I'll borrow this.
Yes, you may.
We will get to how you do that. That's a very good question from the audience. Let me just say that on the day that John Bolton made his threats to the ICC, the Green Party of the United States voted by almost 100% to file complaints with the ICC against Israel and urging further investigation. Further, I think we need to amend those complaints now to include John Bolton as a suspect in those investigations because of his strong support for Israel and his threats to the ICC. We're going to do a deeper dive now into this and go back beyond, even longer into history and how war has been against the law. Our next speaker, Daniel Turp, is a tenured professor, faculty of law at the University of Montreal since 1982. He teaches public international law, international and constitutional law as it affects basic human rights as well as advanced constitutional law. He's president of the Quebec Association of Constitutional Law and president of the Quebec Society of International Law. He's going to talk about how the Kellogg-Briand Act is the basis of international laws against war, and how we can use those laws to compel their support. Please welcome Daniel.
Well, thank you very much. Thank you, Mr. Swanson and the organizers of this conference to have allowed me to have a great train ride from Montreal to Toronto with 45 minutes of how do you say, of retard. It was late, as usual, but I made it. I thank Gail Davidson as well and other people that have, I guess, asked me to talk about something I'm doing with students of my law school at the Université de Montréal. And yes, maybe it is linked with the Briand-Kellogg Pact and the Charter of United Nations, which makes every war illegal. Every war. I try to convince my students that war is illegal, and I read the charter and I say, you can only use force. You can't do wars. You can't wage wars anymore. It's illegal under the United Nations Charter. But I realize that young people, my students at the law faculty of the Université de Montréal, believe that wars are illegal and that some things are not morally acceptable, that when things are illegal, you have to do something about it. And that's why in the past years, I've been working with students and bringing cases before Canadian courts, because it's not only international law that can allow us to do something about wars or about trade in arms. And I guess that's what I've been asked to talk to you about for 15 minutes. I'll try to be as good as Gail. Maybe you could keep my time as well. So I want to talk to you about this contract that the Canadian Commercial Corporation has made with the Saudi Arabia National Guard to sell what is called light armored vehicles. And to tell you how we have brought at least 2 cases before the Federal Court of Canada in trying to make courts declare illegal the fact that Canada could export these vehicles to Saudi Arabia. And it's something I've decided to do because at one point there was a new government in Canada, Justin Trudeau's new government. Everyone thought this was great. Everything thought that human rights would be even better served under Justin Trudeau's government. But one of the first things the Trudeau government did is agree with the previous government, the Conservative government, and go ahead with this $15 billion contract to sell light armor vehicles that in most cases are tanks, real tanks. They're not trucks, they're not jeeps, they're real tanks, very dangerous military equipment. And the Trudeau government just said, yes, we have to go ahead with this. There's a contract. We have to respect this contract. And thus, let's deliver these export permits under this legislation, which allows Canada to export military equipment to other countries and give permits for that purpose. So when I heard about that, I was not very happy, and I talked to my students about that, and I said, who would like to be involved with me in bringing a case before the federal court? Because there is some law in our books, in our statute books, and there's guidelines that we could invoke in courts to suggest that this shouldn't have happened, and that what has happened, delivering these export permits is illegal under Canadian law, but also international law, under the Geneva Conventions. So you know, I gave you a bit about the facts because this contract is something that obviously is something the Canadian government wanted to do, and it wanted to, and still wants, obviously, to sell this very dangerous equipment to Saudi Arabia. Saudi Arabia. You know, the country that has the worst record when it comes to human rights in the world. You know, every NGO, Amnesty International, Human Rights Watch, and others, you know, rank Saudi Arabia as the worst country in the world when it comes to human rights. And Canada wants to sell, you know, tanks to Saudi Arabia. It's not the only country. France sells tanks, Germany sells tanks. Trump loves Saudi Arabia, and he wants them to buy American tanks as well. But Canada, well, you know, I thought, and I still think that this is unacceptable. So looking at those facts and having convinced, and it was easy, some students to jump on board, we created this, what we call the Armored Rights Operation, Opération Droit Blindé. You know, we want rights to be armored, not vehicles to kill people. So we, I got a lot of students involved, these young men and women who are really keen about doing something about this. And I have 2 generations of students now. I'll show you pictures of them at the end of this of my presentation. About 75 students have been helping me in the past 2 years to bring this case. So looking at the facts, what we decided to do is file in front of the Federal Court of Canada what we call an application for judicial remedy, which is a remedy which allows us to strike down a decision by the Minister of Foreign Affairs relating to the deliverance of these export permits. And the government did issue those permits, and it's interesting to tell that these permits were issued even after we brought this case before the court. And a few weeks after we brought the case before the court, we were asking the court at first to say that they shouldn't deliver them, but they delivered them a few weeks later. So we had even to change our procedure to ask them to annul the permits that had been delivered. So we brought this case before the federal court, and the case was brought on the basis of law. It's the rule of law that here was in our minds, because Canada has this Export and Import Permits Act that allows the sale and the export of even military equipment. But in 1986, Joe Clark, as he then was, who was the Minister of External Affairs then, he issued guidelines that said, and I'll quote them, that you shouldn't sell military equipment to countries that don't respect human rights. I'll read these guidelines. Guidelines concerning the export of military and strategic equipment. These guidelines reflect the principles of the aforementioned 1986 export control policy and provide that the export of military equipment must be subject to strict controls to, and I quote, countries where citizens' rights are subject to serious and repeated violations by the government unless it can be demonstrated that there is no reasonable risk that the material will be used against the civilian population. So it sounds quite reasonable, you know, that you shouldn't send equipment to those countries where there's a risk that these equipment be used to breach human rights. So we brought the legal challenge. We argued a case before the Federal Court of Canada, and we tried to prove that there was a reasonable risk in the light of what Saudi Arabia does to its own population, and the light of what Saudi Arabia has been doing in Yemen as the leader of this coalition, killing so many civilians, so many children. we argue that, there was a breach of these guidelines and the Export Permits Act, and also of the Geneva Conventions because of what was happening in Yemen. We argued our case. We were convinced that we'd win, but we lost. We lost in front of the federal court, but we appealed to the Federal Court of Appeal. And a few weeks ago, the Federal Court of Appeal also rejected our appeal because they said, well, because Canadian tanks hadn't been used before, and you can't prove that Canadian tanks were used in Saudi Arabia or in Yemen, there's no reasonable risk. That was a conclusion. And we're very upset because that's not what the law says, and that's not how it should be interpreted. And that's why we're now trying to get the Supreme Court of Canada to go and listen to our arguments. We will be filing in the next few days our request to be authorized to go to the Supreme Court of Canada because it's not automatic. The court has to allow us to argue our case. And so that's where we are with my students. We're really convinced that this is something that should be done. We've done it, and we also brought a second case because last summer there was more evidence that Saudi Arabia had used than Canadian tanks. There was evidence, Globe and Mail, Stephen Chase, the journalist of the Globe and Mail, who's doing a great job as a journalist to see what's happening in Saudi Arabia and what Canadian equipment is being used, how it's being used there and in Yemen. Well, we brought a second case. And the government was so upset at us. We brought a second case. They tried to strike this case. There was a motion to strike our second case, but they lost. We won this case, and the court said, well, no, there is a possibility that they'll win their case. There is some evidence that maybe there is a risk. That's the Judge Martineau that said that in January of 2008. But we suspended this second case because we're waiting for the decision of the Supreme Court at one point on points of law. So I'll be able to talk a bit more and I'll answer your questions. But at the end, and I've written a paper. You can go and read the whole paper on my website. But at the end, why do I do this, and why do my students follow me in doing this? Why do I have two great lawyers who are doing this pro bono? I don't have to pay the really big lawyer fees there, and they're socially conscious, these two great lawyers of ours. We do this because it's morally wrong to sell arms to Saudi Arabia or any other country that breaches human rights. But it's also politically irresponsible to do something like that as well. Politically irresponsible. But from a legal standpoint, from the rule of law standpoint, it is illegal to sell arms to Saudi Arabia. It's illegal under Canadian law, and it's illegal under international law. That's why we're doing this. And I want to show you my students. How can I get to the, so I want to show you, I'm very proud of my students. So this is the first generation. In the first academic year in 2016-17, there was about 50 students of mine that were working on the case. And last year, there were 40. But they're not all on the picture as you see, and now I have to find another generation. They're at the bar school, and or at the Chambre des Notaires, or they're studying abroad, doing master degrees in law. But it gives me pride and, in a sense, some optimism about the idea that there are some people that want to do things about human rights, that are against war, and that are ready to invest time and energy to make things happen and to stop this arms trade with Saudi Arabia or any other country that doesn't respect human rights and the dignity of human life. Thank you.
Okay, excellent. Thank you very much for that. There's a web of laws that relate to all of this, but there are new forms of war coming at us, and as a result, new laws are needed. Our next speaker will speak to some of these issues. Ray Acheson is the director of Reaching Critical Will, the disarmament program of the Women's International League for Peace and Freedom. Ray leads WILP's work advocating for disarmament and stigmatizing war and violence, and represents WILP on various campaigns and coalitions. This includes the International Steering Group of the International Campaign to Abolish Nuclear Weapons, which won the Nobel Prize in 2017 for its championing a treaty on the prohibition of nuclear weapons. Ray brings a feminist perspective to disarmament work, including in her campaigning against nuclear weapons, killer robots, the international arms trade, and more. Ray has a bachelor's honors degree in peace and conflict studies from the University of Toronto and a master's in politics from the New School for Social Research. Today she'll talk about ICANN's work to advocate for the nuclear weapon ban treaty, which was adopted by the United Nations in 2017 over the objections of the most militarily powerful countries in the world. She'll talk about how governments and activists work together to achieve this feat and what lessons can be learned for our campaigning against other weapons in war. Please welcome Ray.
Thanks, everybody. It's really, really good to be home. I'm living in New York City, and I have been for a few years, and people ask me why all the time when I could live in Toronto, and it's an excellent question to which I don't really have an answer except that the UN is there. So that's where I am for right now. I really learned so much from listening to Christine and Raven talk tonight. I thought that their talks to us were just extraordinary. And what it really drew out for me was the importance of hope and the importance of community and the importance of letting those affected lead us in our work against war and against weapons. And I wanted to sort of bring those frames back into what we're talking about tonight, because I think it really underpins all of the work that we're doing, whether it's to stop weapons sales to Saudi Arabia, which is so important, to bring peace to the Korean Peninsula that Christine talked about, or whether it's getting rid of nuclear weapons, which is what I'm going to talk about now. So I have a story to tell you, and I'm going to have to tell it really quickly because I don't have a lot of time, but it's a pretty good story. It starts a long time ago, in 1945, with the invention of nuclear weapons. And it goes up to today and into the future because, of course, we have not gotten rid of these weapons, but we've made some serious ground in disrupting nuclear weapons recently. So first of all, the problem, because as a peace movement, we're very good at setting out the problem. I'll do it very quickly because you all know what it is. We have about 14,000 nuclear weapons still in existence, down from about 70,000. Woohoo! So that's good. Still a long way to go, of course. The problem is that while the numbers have gone down since the end of the Cold War, the money being poured into these systems has not gone down. And in fact, it's been going up and up and up and up. And it went up under the Obama administration, and it's going up now. Billions of dollars being spent in the United States on its nuclear weapons, but also in Russia, in China, in India, France, the UK. Every country that has nuclear weapons is investing money into refurbishing their arsenals. They call it modernization, which is a euphemism for extending the lives of these death machines into the indefinite future. We've also had a number of challenges in the international community with these weapons. There are treaties, there is law already that says that nuclear weapons should not be proliferated, that states that didn't have them by the time the Non-Proliferation Treaty was signed can't get them, and the rest have to get rid of them. They haven't complied with this since 1970. The states that have nuclear weapons, they're legally obligated to eliminate their arsenals and have not complied with that. There's other law regulating testing, there's bilateral arrangements, there's a lot of treaty law, there is a lot of agreements going on around nuclear weapons. And we just haven't seen the right tools and the right political will from the countries with these weapons. And so this has left us in a situation of frustration, because what is it that we can do as people, as citizens of this world? What is it that the countries that don't have nuclear weapons, that have rejected nuclear weapons, can do? This is the vast majority of countries in the world. We're talking about 9 states that have nuclear weapons. 9 states are holding the rest of us ransom. And the rest of the world has categorically rejected these weapons. But what can they actually do about it? How can they help compel the nuclear armed states to eliminate their arsenals? So while we've had these disappointments, these frustrations, the reinvestment in nuclear weapons, we've also had some positive lessons. And so 2 of these lessons came from prohibitions of other weapon systems, landmines and cluster bombs. There was effective campaigns from civil society movements working closely with governments to prohibit and eliminate these weapons on the basis of them being indiscriminate and causing harm to civilians. And the approach that they took was to really look at how the normative effects of stigmatization of these weapon systems being enshrined in prohibition law could help lead to disarmament programs, destruction programs, cleanup, remediation, victim assistance, and economic divestment from these weapons so that they wouldn't be produced and used again. And so we thought, a number of us, working with like-minded governments that were frustrated, thought we could try this with nuclear weapons. And so in around a little bit before 2010, we started really considering this as a possibility. And of course, at that time, we were told we were crazy. Nuclear weapons are different, right? They're different than all those other weapons. They can't possibly be subjected to the same kind of law as these other weapon systems. It's a completely different situation. Nuclear weapons are for deterrence. They're not meant to be used, right? These were the types of arguments that we heard, and we were told that there was no point in trying this. And we were actually told this not just by the nuclear armed states, but some of their allies that were sheltering behind their nuclear weapons as tools of supposed security, and also by some civil society groups who just really thought that what we needed to do was keep after the nuclear armed states, just keep saying they have to disarm, they have to comply with their law, rather than creating new law, creating a prohibition treaty, even without those states on board. But we wanted to try because we felt that the situation that we were living with was untenable and unacceptable. And so we wanted to give it a go. And we did this in sort of 2 tracks of work. One was public and one was quiet. So the public was pretty exciting. We had a series of global conferences on the humanitarian impact of nuclear weapons with the purpose of seizing the discourse around nuclear weapons, taking it back from those that had turned it into a techno-strategic jargon about how nuclear weapons are instrumental for our security, how they're somehow magical tools that prevent war. And really breaking that down, disrupting that narrative, showing it to be false as it is, talking about nuclear weapons as tools of violence, of massive nuclear violence, talking about what nuclear weapons do to the environment, to the human bodies. This was not new. This has been done. Many of you have worked on these campaigns in the past. It was done in the 60s, it was done in the 80s, it has been done. But what we wanted to do was bring this to a new generation of diplomats and a new generation of activists who were working from very new perspectives around the world. The anti-nuclear movement has been vibrant, it has been resilient and long-lasting, but we really wanted to bring this to the next generation to have leadership from those that maybe hadn't led in this movement before. This movement, this change of discourse, this confrontation of the nuclear powers was led by activists and diplomats from the global south. It was led by survivors, people that had survived Hiroshima and Nagasaki, people who survived atomic testing in Australia, the Marshall Islands, and other countries around the world. It was led by women, it was led by queer people, and it was led by a lot of young people as well. And so we really took what we like to call in the feminist lingo today, feminist intersectionality. That's what we did with our campaign, even if we didn't always have that language. We wanted to be diverse. We wanted to bring new voices into this movement and have it be their movement, and to really challenge the approach that the nuclear armed states took, this very patriarchal, dominant, colonial approach that these states take to their power and their privilege in the international system. And we confronted that. That was our public goal, was to confront that and deconstruct that and mess it all up for them, basically. At the same time, this very public series of meetings, public writings, speaking, conferences, etc. was going on, we also had some really quiet work in the background. And so some of us from the civil society side, working with the International Committee of the Red Cross and a cross-regional section of governments, very quietly building up trust and community amongst ourselves as partners, building up an understanding of what the law could look like, what the law could do, what the pressure points were going to be coming from the nuclear armed, and how to protect against that once we took this public and once we really made the advance. And so this quiet work was happening at the same time as this public restructuring was happening. In our work, in both the public and private sort of actions that were going on, we were actually aided to a large extent by the nuclear armed states and by some of their nuclear weapon-loving allies. And that was because of their arrogance. And so this is a really interesting phenomenon that I think has resonance across issues. But they boycotted all of those public meetings. They refused to come to meetings that were about their weapons. They wouldn't even show up to talk about how their weapons might affect people, bodies, environments. Okay. They exerted a very colonial pressure upon states once they realized that we were going forward with a prohibition on nuclear weapons. So the French were sent after the Francophone African countries. The British went after a lot of their former colonies. The Americans went after everybody because that's just what they do. But they're unleashing their sort of colonial arrogance. They're feeling that they could tell these countries what they could and couldn't do, which they always do and feel that they can get away with. They couldn't get away with it this time. And that's because we spent years building up these networks of governments, of government officials, and of activists, and of the Red Cross, and of so many different people coming at this from many different perspectives and feeling engaged and feeling ownership over this issue, that they wouldn't want to back down. And they knew they had the strength in numbers. They knew they had the majority. They knew that from the very beginning. And so having that, I think, really, really helped as well. But the nuclear armed states continued with their arrogant posturing and continue to do so today, as the treaty is now in the second phase of its work. So because I have only a couple minutes, I'm going to skip over the treaty itself, but it's awesome. It's right here. We have a few copies, and it's also online. It prohibits nuclear weapons comprehensively. It provides space for disarmament when the nuclear armed states join it. And it contains obligations around victim assistance and environmental remediation. It includes groundbreaking language around the effects of nuclear weapons on indigenous communities and on women, and encourages the participation of women in disarmament. So it breaks a lot of ground in so many different ways, and it's really, I'm sorry I don't have time to go into it right now, because what I want to say is that the activism now in the ICANN campaign is focused on getting this treaty into force. We need 50 countries to ratify it to enter into force. We're on the way. We are active across the world. We have our treaty coordinator here, Tim Wright, from Australia. He's doing awesome work with a massive team of campaigners that are working to get the countries that supported this treaty already to put it through their parliament's national legislative process. We have 15 ratifications and 60 signatures. And we're going to have a bunch more coming in next week. There's going to be a special ceremony at the UN on the 26th of September, so we'll have a few more then. And this pace is basically normal for treaty entry into force. It usually takes a couple years once the treaty is adopted. So we're on track, we're looking good, but we need to keep up the momentum. In the meantime, we're also going for those states that don't support the treaty. And there's some really, really cool activism happening around the world on this. Right now, yes, this counts. Toronto actually did something really cool, and the city council adopted a resolution supporting the ban treaty and calling on the federal government to join it. Yay, Toronto. Thank you to everybody here that might have worked on that. This is something that all of you can work on in your cities. If we get all the cities in our countries to be supportive of this treaty, that will be very significant. The state of California in the US has done something similar, so have some cities in the US as well. So this process is underway, and it's something everybody can do. Economic divestment is another huge thing that you can work on. You can call your bank and see if your bank has financial investments in nuclear weapons. If you want that information, we have a website called don'tbankonthebomb.com. It's got all the companies, all the banks, and there's going to be a huge action around that on the 26th of September as well. There's also like crazy things you can do. In Australia, they just went on a 900-kilometer bike ride from Melbourne to Canberra carrying the Nobel Peace Prize and stopping in all the towns along the way and lobbying MPs and talking to the public. So the options are endless of what you can do to make this treaty visible and meaningful and resonate with people. 1 minute? Excellent. Okay. My last 1 minute will be spent on what the heck does prohibiting nuclear weapons have to do with abolishing war? So I think we can all probably answer that, but I've been thinking about this a little bit recently in the context of one of my early mentors, whose name is Randy Forsberg. Some of you may have worked with her. She was one of the leaders of the nuclear freeze movement back in the 80s. And she had a much bigger vision than just, stopping the arms race or even than eliminating nuclear weapons. Her vision was the abolition of war. And I think that what ICANN has done with this treaty, what so many other activists are working on with humanitarian disarmament, with stopping arms sales, with confronting violence and power, all of this is tied into a much bigger picture of stigmatizing violence, stigmatizing the social practice of war, banning weapons or stopping certain practices in conflict, constraining the use of force. All of this can be tied into a much bigger project of abolishing war. And I think that this iterative and relentless process is how we're going to have success across not just our individual goals, whatever we might be working on in our communities or the international community, but how we can advance collectively this overall project of abolishing war. Thanks.
Beautiful. Wow. Well, that was 3 great panelists. Thank you all very much for your great work. That last panel is kind of almost like a case study in our final plenary, which is on how we build this movement to abolish war. So that'll be on the last panel tomorrow. We now have about 35 minutes for questions. We have 2 people with microphones. Liz and Melissa, where are you? Do you have your mics? Okay. One take one side of the room, the other the other. And if you have a question, put your hand up. We'll send a microphone over. Is your mic on? Okay. Here's the question right there. Oh, there's one closer down. Go ahead. You're in charge. Go. Who has a hand up? Yeah, what's up to you?
Thank you for a wonderful panel. I just want to ask about this idea that you shouldn't sell military weapons to a country that might abuse human rights, because I don't understand how you can use military weapons and not abuse human rights. And there seems to be a misunderstanding built into the whole idea. Can you comment?
Well, you know, countries that think that have adopted laws, and the UK, France, most countries, those who claim to be democratic, have adopted legislation. Those export permits acts here in Canada, in the UK, in many other countries, even within the European Union, do provide for prohibitions to sell arms to countries that do not respect human rights. But they're not applying them. They're just not applying. Even here in Canada, the government has, there was a report by someone in Maclean's or L'Actualité in Quebec who showed that Canada's selling is accepting 99% of the arms sales, and including to countries that, you know, have terrible human rights records. So that's domestic law, but there's international law. There's, you know, the Geneva Conventions, because you're supposed to, when you're a party to the Geneva Convention, not only to respect the Geneva Convention, you're supposed to ensure the respect by other countries of the Geneva Conventions, and that implies for many scholars that you can't sell weapons to countries that will not respect humanitarian law. And now there's the new treaty, not your new treaty, but the other treaty on arms trade that also provides that countries should not sell arms to countries where there's a risk that they be used against human rights. So the problem is applying these norms and making sure that countries abide by their norms. But they're not doing it. Even here in Canada, it's something that we would not think Canada is not doing, but Canada is selling arms. And Monsieur Dion, the former foreign affairs minister, when it came to decide if he would go ahead with this contract done by the Conservatives, he said, well, if we don't sell arms to Saudi Arabia, others will. Wow, that's a great argument. Isn't it a great argument?
They don't bomb their own people. It's bombing your own people is the problem. We have a question on the other side of the room.
Hi there. Just first of all, thank you all. You all were incredible speakers. And this question sort of related to all of your guys' ideas as well as the last panel. I believe it was Raven who pointed out creative activism. So I've noticed so many different examples of creative activism in the different ways that we're furthering our initiatives for peace. I think that is a really important concept when we go into the next generation and involving people who are closer to my age. But I think, do you guys have any ideas or about how to further creative activism, if that makes sense?
Yeah, I think our best approach to being creative has just been to get together with people that you love and come up with wild ideas and just do it. Honestly, we've had the most fun. You know, a lot of our work getting the nuclear ban treaty, we were in the basement of the United Nations a lot. And I think that once we got out of that space and are now in the sort of public promotion, we're having so much fun with it. So we created this really campy project called TESS, the Treaty Enforcement Squad. And we have red jumpers. I had a slideshow and then I forgot completely to give the thing in, so it's right here. But yeah, so we have these red jumpers with like TESS on the back, and we go around to different nuclear sites and do little performances, and it's sure. So I think that the main thing is that you're having fun while you're doing it, and that you're reaching people and talking to people in communities in ways that resonate with them. So it's not about sitting here with the treaty and going through it, but you're actually pointing out that, you know, with Tess, it's pointing out that this has implications on the ground for people's lives. So I would say that, do whatever you feel like, basically.
We'll try to get those slides.
Can I add something?
Oh, go ahead, sure.
Well, you know,
Talk to the mic.
strategic litigation is very important. I think you have to, as Gail said, there is law. There's a lot of law. There's statutes, there's guidelines, there's treaties. You have to now decide that you take the law in your own hands, because governments are not abiding by their own commitment, and someone has to tell them, and someone has to go before courts and hoping that judges will at one point say enough is enough. You know, this is the law. You've ratified these treaties. You had your parliaments adopt these laws, though. You have to respect them. The problem is that we don't have very audacious judges. They always want to be promoted judges of the Court of Appeal or judge of the Supreme Court. But once in a while, there's a great judge there. There's Rosie Abella, the Supreme Court. I hope Rosie Abella will hear our case, because she might agree with us on this Saudi Arabia case. So, and when you do that, that's what I find great. My students, your age, they want to get involved. They want to do something. They believe in it. And that's, I think, what we should do in all law schools, all over Canada and all over the world, because that might change many things.
Hey, we have a question over here.
René Castroposo, Toronto. I would like to say to Dr. Lawyer Gail about we need to go to the criminal court, international, yes, for genocides, because all the presidents in the United States are genocides. But there are other things I am very worried, is the blockade in Cuba, more 50 years, almost 60 years, Venezuela now, and Korea. Because this is a lenta is no slowly, is lento, the meaning is slow.
Beautiful.
Huh?
Beautiful.
No,
Linda?
lento, no linda, lenta.
Oh.
Is
Slow.
the people is dying, also. Slow death for million people, the blockade, because the people doesn't have medicine, doesn't have a lot of things related with the science or the commerce, the trade with other countries. This is my very, very worry. I would like to know if we will take the rules, the laws for this crime.
I'm not entirely sure what you're asking, but if you're asking if we should be bringing people that, government officials that promote and enforce blockades, is that what you're asking? Absolutely, absolutely. Like one of the parts, the definition of the crime of aggression in the international, in the Rome Statute, it's very, very long. It goes on and on, the brand new one as of last July. It includes blockades as one of the prohibited acts of aggression. And in Yemen right now, now Daniel can probably help me what percentage of the country, 22.2 million of so what's that, like 2/3 of people in Yemen are in a severe humanitarian crisis, and
Including
over
5 million children, we heard the other day.
Correct.
5 million children.
Yes. And what is it, 11 million people are facing starvation by famine. And the United Nations Human Rights Council appointed a panel of independent experts to look at crimes in Yemen. and they found that it's horrible, like, to read their report. It's very short. It's available online. Anybody can read it. But anyway, one of the things that they said was that Saudi Arabia's refusal to ease up any of their blockades was causing millions of people to be facing starvation in Yemen. So absolutely. And if you look at the way that the crime of aggression is so miserable because it's so small, but on the other hand, you could argue this. You could, and anybody can do this. You don't have to be a lawyer to do this. The fact that the aggression is now a crime. You see, crimes against humanity and war crimes under the Rome Statute, there's all kinds of possible justifications. And one of the big justifications is that, all those civilians were killed and those villages burned and all that property destroyed and all the necessary infrastructure was destroyed because there was a military necessity. So that kind of gets shrunk down to almost nothing when you introduce the crime of aggression, because even if because you can argue that there couldn't have been a military necessity now I'm just going to get confused. So yes, I do think that, and the way that they've expanded the jurisdiction possibly with Myanmar, because the criminal court recently said, Myanmar is not a member of the Rome Statute, but Bangladesh is. So he said, okay, well, we could investigate the crime of deportation because of the fact that there's nearly a million people, Rohingya people from Myanmar that have had to flee to Bangladesh. But then they've said, no, let's look at Section 6C of the Rome Statute that talks about persecution, because persecution is a continuing thing, and it's a deprivation of dignity and their rights to all kinds of things to life. And the people in Bangladesh are still suffering that persecution because of the atrocities committed against them in Myanmar. I know this sounds convoluted, but then they're saying, hey, so we can actually investigate those crimes by the Myanmar military. So yeah, I agree. Okay. And I agree that there's ways to consider trying to do that.
Question on the other side of the room?
Just checking this, yeah, okay. On the issue of Canada, hypocrisy, and nuclear power, I don't know how many people here know this, but Canada has, in fact, Ontario has one of the world's, officially the world's largest nuclear power plant. And it's not even that far from here. It's about 3 hours drive. And it supplies way more than enough power than we realistically need, in combining with a whole bunch of other nuclear power plants that are also in Canada. And to make it even worse, we're sitting on top of a huge amount of the world's natural uranium deposits. Now, I gotta ask, anybody who's a Canadian here knows just how ridiculously high the power bills are. So I gotta ask, where's all that nuclear power actually going, and what the hell is it being used for in the first place? You know, I mean, we've got the world's most efficient / safe nuclear reactors. I just went on a tour to that nuclear reactor, the Bruce Power Plant, myself not that long ago on my summer vacation with my parents and a friend from school. And the place was huge and sprawling, and you literally don't even know it's there until you're through the gates. You still don't even know it's there. It's huge. It's very well concealed, and it's really, it's just one of those things.
We get your point. Anyone have any response to that, or we should go on another? Okay, let's have a question here.
Yeah.
Thank you. Alan Ware from New Zealand and a consultant with the International Association of Lawyers Against Nuclear Arms. A comment and a question to Mr. Turp. Firstly, court cases can be really important. You know, we won one in the International Court of Justice in '96, affirming the illegality of the threat or use of nuclear weapons. That was very important in laying down that normative prohibition. I've just been in New York with the Earth Guardians, who've got the case against the US administration on climate change, and they're doing it on behalf of future generations, and they've actually got standing in the court on behalf of future generations. So courts can do a lot, and all the best with your court case. And the question is, and it's about your comment about when you're talking to your students, that war is already prohibited. I think most people in the world don't know that.
Exactly.
And I was talking with Louise Doswell Beck a little while back. She was instrumental when she was with the International Commission on the Red Cross of getting understanding around the world that civilians are protected in war. People didn't used to recognize that, but now virtually everybody knows that it's illegal to kill civilians in wartime. Can we get the same sort of campaign about Article 2.4 of the UN Charter so that everybody in the world knows that war is illegal?
Very good question. Any comment?
Well, that's a great idea, and you know, we should start in I do it at the beginning of my lectures in international law. I read this beautiful poetic preamble of the United Nations Charter. I don't know if you've ever read it, but you know, we the people of the United Nations determined to save succeeding generations from the scourge of war, and which twice in our lifetime has brought untold sorrow. In French, it's d'indicible souffrance. It's so beautiful, it's poetic. To mankind, we'd say humankind today, or peoplekind. So that's a way to start, and to remind people that war is illegal, and to be very rigorous when it comes to law. I have to say, well, the use of force is not prohibited. The use of force is, but war is prohibited. Use of force only if it's authorized by the Security Council, or Article 51 of the Charter can be invoked because of self-defense. So I think it would be a very good idea to remind people that war is illegal, because it's as if it wasn't. And we've forgotten that we've prohibited war in the Charter, and we started with the Pacte Briand-Kellogg. So, you know, I think a lot of young people would be even more concerned about a war. And you know what I always remind them, because it's interesting, even in the terminology, the Charter of the United States, the United Nations, uses the word war only in the preamble. Even the word has been, you know, put aside, because the word means a lot. Words mean a lot. And if you continue talking about war, even crimes of war, we've kept that, crimes of war. But for the rest, we've decided even to use the language to say war is not acceptable, and we won't even call it like that.
Okay.
Would the panel speak something about Israel, about Jewish power, about the effect of Israeli politics in America prohibiting any touching of these legal questions? Israel is one of the greatest violators of all these conventions of human rights, of use of military weapons against populations, and yet it seems most difficult to talk about Israel, Jewish power in America and in Canada, and making open the question of the application of human rights law to the actual politics of the Jewish-Israeli state. Could the participants in the panel say something about how come Israel is so difficult to talk about?
Can I just say one thing? I'm sure everybody else has something to say, but a tiny piece of good news in July of this year, the International Criminal Court announced a pre-investigation. You don't have to know what all the pre's are about, but anyway, into crimes by Israel in the state of Palestine. And that was one of the things that prompted Mr. Bolton to say, don't even think about coming after us. And, you know, the United States and Israel, although they're not, neither of them are parties to the Rome Statute, they've been very, very, very influential in the development of the criminal court, and they're kind of reining it in. And I don't think maybe I'm being too optimistic, but I think there's been a break in that era, and I think that that's changed. And so Anyway, so I don't know if that answers your question. But, you know, if you look back, so for instance, one of the things I didn't get to say in my talk was that the blowback for many people who try and fight these things is very severe, because look at what happened to the British lawyer Phil Shiner, for instance, who took complaints about the UK crimes in Iraq to the UK courts and the European Court of Appeal successfully. Well, Phil ended up being disbarred, criminally charged, fined, and finally bankrupted. And then you look at what happened to Judge Baltasar Garzon, the famous Spanish judge, who he was famous for issuing the international arrest warrant against Augusto Pinochet. And he was a total passionate advocate for using the law to hold state officials accountable for international crimes. Do you know what happened to him? He had 2 investigations into Guantanamo Bay torture. One is the torture memos, and one was victim-based. And the United States, through this was released in the WikiLeaks releases, behind the scenes, made sure that they'd get rid of those cases and rid of Garzon. So he was first of all suspended, then he was criminally charged by, if you can believe it, 2 fascist organizations. Like, believe it, in Spain they have fascist organizations. And then he was permanently removed from the bench. So it's been a very tough fight. When I went to the first meeting of the Assembly of States Parties to the Rome Statute, it was a party. You know, they have a little party and they get served drinks and food and everything, and they have speeches. So there I was. I'd flown across to The Hague from Vancouver, British Columbia. And the 2 speakers who were going to speak at the party, one was an American military person and the other one was an Israeli person. I can't remember, it was a he, but I can't remember if he's military or civil. So I stood up and, you know, I really never need a microphone. And I said, I object to listening to either of these people. I know what they think of the International Criminal Court. All of us had come, most of us on our own dime, across the world to support the creation of this court and to hear what people who care to create it and support it have to say. And if they're going to speak, I'm leaving. And they said he was speaking, so of course I had to leave. Anyway,
Okay.
so, but they've been very, very powerful.
Question on this side over here.
Thank you very much. Is that close enough?
You're on.
I have 2 things, and they're both about the illegality of war. Nobody else has, Dorothy. My name's Judy Berlin. I live in Montreal. The first is that war may be illegal, but it's also a very big business. Right. And until we tackle that, I think we're not going to get anywhere. I once heard the best speech I've ever heard made by a woman from Hamilton, whose name I forget, at a protest outside the Armex 89. This is in 1989, the big arms trade fair in Ottawa. And I don't think many Canadians realize to what extent Canada is involved in the international weapons trade, never mind the labs to Saudi Arabia. Anyway, it was 2 sentences long, so I'm going to repeat it verbatim. She said, there are 4 trades that create victims. They are the slave trade, the drug trade, the sex trade, and the arms trade. She didn't say another word. But if you accept, as I do, that these 4 forms of commerce belong in the same ethical basket, because you can't make a buck out of any of them without directly victimizing other human beings, then you have to ask yourself, why do we accept the arms trade at all as just businesses?
I just have time for that question. We just have time for that.
Second one is
Be quick, please.
It's about another article in the UN Charter besides 24, and that's 103. But I'd like to know if it's right or not in my thinking that the specific thing that made the war in Afghanistan illegal is the fact that Canada and other countries used the Article 5 of the NATO agreement to trump the Charter of the United Nations, which Article 103 of the United Nations says you can't do. Is that correct or not correct?
Well, it's correct because Article 103, it's interesting, in international law, creates a hierarchy between the Charter of the United Nations and other treaties. And other treaties cannot be inconsistent with the Charter. It's very unique. That's why sometimes people say that the Charter of the UN is like the constitution of the world, because it has some supremacy on other treaties, like the NATO treaty. But then it's about the implementation, about l'effectivité, we'd say in French. And the NATO treaty is obviously, it has been in that case much more effective than the United Nations Charter. But we have legal grounds to say that what was said about the relationship between the NATO treaty and the Charter of the United is inconsistent with the Constitution of the world, which is the United Nations Charter.
Okay, we are running out of time. Let me, we have time for one more question. Let me just make a couple of announcements before we do the last question, because everyone will leave when all the questions are done. First off, Canadian Voice of Women for Peace is hosting an inspirational Women in Peace brunch on Sunday morning, 10 a.m. to 12. Medea Benjamin and Ray Acheson will be speaking at that. You can purchase your tickets at the Canadian Voice Women for Peace table at the conference. Second, the first panel on Saturday starts at 9 a.m. in the main auditorium right here. Doors open at 8 a.m. for coffee, tea, and snacks, and browsing organization tables. Don't forget to wear your lanyard, which is your ticket to get back in, and you enjoy the evening after that. You want to make us? Oh, that's it. And then we have one more question. Where's the? What? I see.
Right here.
Okay, go ahead. Go ahead.
I was displaced from my home in Palestine when I was 12 years old, and I came to Michigan for the last 70 years. And while I was growing up, people would ask me, "Where are you from?" And I would say, "Palestine." And they say, "What is that?" And since 1977, I've been fully devoted to world peace. And when I talk to people about world peace, they say, "Oh, it'll never happen. Not in my lifetime." So I'm just so proud to tell you that I'm glad for the World Beyond War. The world is my citizenship. All the speakers. I am so buoyed up and so excited about being regenerated again, both about Palestine and about peace. I do want to say about creative solutions that when a car is made, they put a VIN number. And anytime you switch cars, you have to register it, you have to give the price, and you have to tell who bought it and who sold it. We should do that with all weapons. All weapons, handguns all the way to bombs and airplanes. And then we will know who sells them to whom and why. And for Palestine, we need to open up the international media. Why is it that North Korea, we blame North Korea for being closed down? Well, Israel is closed down. I've never heard an international report from Israel. So these are creative ideas that we need to look at that go along with all the laws and abolishing nuclear weapons is a no-brainer. I mean, there should be no reason we need to be nuclear free.
Okay, thank you very much. I was very optimistic that this conference is really, I just want to say this conference is one example of many of a reconnecting of the anti-war movement. And there's going to be a number of events coming up this fall. I just want to mention quickly, October 21st, there's a Women's March on the Pentagon. November 10th, we're having a Peace Congress in Washington, D.C., where leaders of peace groups are going to get together to talk about where we go from here, and there'll be a march after we stop the Trump military parade, which was canceled thanks to a large work by a lot of different organizations. There's also going to be a silent march on the Pentagon, on the Mall in Washington, D.C. on Veterans Day to try to reclaim Armistice Day. And then in Dublin, Ireland, I want to mention the No Bases Conference, November 16th to 18th. This is a great campaign to close U.S. military bases, very consistent with ending U.S. empire. Anyone with final comment from our panel? We're pretty much over time, but anyone want to squeeze something in? I guess not. All right.
Happy International Day of Peace. You know, we have to remind ourselves that it's the International Day of Peace today.
Please look around you, and even if it's not your trash, if you see trash, please pick it up so we can be responsible and keep the place tidy. Thank you.